Hi, everyone. I'm Steve Merksamer, and I'm the current chair of PPIC. And on behalf of our board of directors, it is my privilege to welcome you to our program today featuring Chief Justice Tani Cantil-Sakauye. Our Chief Justice has served over 28 years on the bench as a trial judge, Court of Appeal justice, and since January 2010, Chief Justice. As the head of our third branch of government, and is the third branch of government, she has streamlined the Judicial Council, enhanced efficiency and access to justice, promoted civics literacy in our schools, and much more, all while carrying and deciding a full caseload. So thank you, Chief, very much for joining us today. We very much appreciate your presence. As many of you know, this event is part of PPIC's 2019 Speaker Series on California's Future, which is sponsored and underwritten by the organizations listed on the screens to my right and to the left here, and on the back of your program. So we're all very grateful at PPIC for this support, and I think we should show it by giving our sponsors and underwriters a nice round of applause. Thank you. This series is also funded by the PPIC Donor Circle and the PPIC Corporate Circle, groups of individuals and organizations that provide generous support to PPIC. And we certainly hope that you consider joining us as a sponsor or a donor so that we can continue to make programs like today's possible and ensure that they remain free, and they are free, and open to the public in person and online. So before we begin, a couple of very quick housekeeping items. PPIC is always trying to enhance these events. Later today, you'll receive an email with a short survey, and we ask that you please take a few moments to let us know how we did. And finally, and most importantly, please silence your cell phones. And so now I am very happy to introduce the moderator of today's conversation with our Chief Justice, PPIC President and CEO, Mark Baldassare.
Thank you. Thank you. Thank you very much, Steve. You reminded me to silence my cell phone. Appreciate it. And thank you for your leadership of PPIC's Board of Directors as our chair. Really appreciate it. Welcome, Chief Justice. It's a pleasure to have you here today. And to all of you, thank you so much for joining us. And I especially want to call out the Chief Justice's husband and daughter who are here today. We really appreciate you being part of this program with us today. Thank you for finding the time. I mean, could anybody think about a more dramatic time? We're listening to the Judiciary Committee of the House this morning, and here we are with our Chief Justice to explain to us about how the different branches of government work and where the judicial branch in California fits in. So we really appreciate you having the time. I know that there are many questions that all of you have, and more than we can possibly get to today, because more than possibly that I can get to. But if you have a question in the course of time, and you haven't already filled out a card, and because there will be a time to take those questions later, just raise your hand, and you notice that there'll be some cards. Somebody will come to your table and take a card if something comes up in the course of this conversation. So there's so many things to talk about in so little time, but before we get started, I know that one of your goals is to bring to Californians what it is that the Supreme Court of California does. And I wonder if you could reflect on one or two things about the work of the court that you want all Californians to know about.
Well, thank you, Mark, and thank you, Steve, for the introduction. I thank PPIC for leading in the voice of important issues for California, and your reports are informative. We read them, we pass them out. I thank you for your interest. Yeah. I think what I would want most people to know about the California Supreme Court is what I would want you to know about the California judiciary. And that is, as Steve indicated, as a third branch of government, We really are a third branch of government. We are not simply a collection of superior courts, courts of appeal, and a Supreme Court. We are a branch. We have a policy-making body called the Judicial Council that is set in our California Constitution. And we are a collective effort because things come up from the trial court to the Court of Appeal to the California Supreme Court. And it's important to know that we are the largest judiciary in the country. We are the largest law-trained judiciary maybe in the world. And I think the second thing I would want all Californians to know is that over 90% of the law that affects your life is made in state courts. It's true that federal courts, the United States Supreme Courts, the district courts, the circuit courts make very important law. But there is no question that 92% of case law is made in the state courts, like California, Nevada, Arizona. And so I am grateful for your interest in the judiciary in a state court.
Thank you. And so when people hear Supreme Court, they're often thinking about the other Supreme Court,
Yes.
right?
Yes.
And when they think about the judiciary branch, they're probably thinking about the U.S. Supreme Court, all the attention it gets, but very little is known about the Supreme Court. We don't get to go inside and see how that operates. So what are you trying to do in California to try to demystify what the courts do so that people have a better understanding of what it is when you say that 90% of the laws are being made?
Well, I would first say that it's understandable that most people understand the federal courts or are aware of the federal courts because, frankly, that's what law schools across the country teach. They teach United States Supreme Court and circuit law. But in fact, most lawyers who graduate will live in a state, and most of them will practice in a state court and learn the state law. So it's understandable that state courts are not as well known. So my continuing effort has been since 2010 and 11 when I first became Chief Justice was to bring the courts to you so that you understand the courts exist for you to press your rights. And it is a forum for an opportunity at justice. And so in that regard, the first thing I did as Chief Justice was I opened up all the meetings of the Judicial Council that involve spending your tax dollars. So if we're talking about spending your money, which funds the judiciary, you can call in, you can get the paperwork ahead of time, and you can see and hear the debate about how your dollars are spent. You can listen to the various people who weigh in and have pros and cons about the decisions the Judicial Council is making. And the second thing that I did after seeing the success of opening up and taping and live webcasting the Judicial Council meetings was to open up and live webcast the California Supreme Court oral arguments. And so now, since now I think about 3 to 4 years, you can go to our court website and you can watch oral arguments in action. And you can also archive and go back 3 to 4 years for cases that you thought were of significance or snippets of cases. And if you're a practitioner and you're appearing before the California Supreme Court, I highly recommend that you watch at least one oral argument so you know what to expect, because it's not scary, but it is an active dialogue, I think, with the people most knowledgeable about that case in that moment. Additionally, what we've tried to do by opening up the understanding of the judiciary is we created the civics education initiative called The Power of Democracy, where we have judges and lawyers, the president of the Cal Chamber of Commerce, labor unions, and scholars, professors come together to teach civics to K through 12 and also adult civics. So we're with an emphasis on the judiciary. But we're trying to get out into your meetings, into your schools, your classrooms, partnering to try to explain what we do so that you have access and you're not afraid or worried or concerned about what we're doing.
So you started the Power of Democracy initiative how many years ago?
2012.
2012. So basically when you took the Chief Justice position. So it's been going on for 7 years. Must have been something you thought about, like when I'm gonna be Chief Justice. This is going to be one of my causes, one of the things that I'm going to do.
Oddly not.
Oddly not. So then what led you to it?
Well, it was 2011 when we were in a great recession and the judicial branch budget was being cut Mid-year, over and over and over, we were in a free fall. We ended up losing over $1.3 billion of our $3 billion budget. We ended up closing 53 courthouses, hundreds and hundreds of courtrooms. We were laying people off. We were going through furlough. And I went to the legislature to plead on behalf of the third branch that we needed adequate, stable, sustainable funding. And I received some quizzical looks, like, well, what agency are you from? How many chiefs are you at one time? Which chief are you? I understand all the judges obey you, and then you obey us. And I thought, a civics education initiative might be in order.
Yeah, for sure. And so as you've gone around and talked, I'm especially interested in what you've heard from students. As interested as I am in what you hear from the legislature too. But you've had a chance to go out and talk to students who've been in classrooms and who've heard about the power of democracy. What are you hearing from them about the courts and about government in general?
I'm hearing from students just this invigorated attitude about wanting to go out into the world and make a difference. Because the way we talk about civics to students is about projects and collaboration and critical thinking through current events, and how the people who lead today really were people like you years ago. So we try to give them analytical, deliberative skills, teach them to work in collaboration on projects, and teach them about the powers and the levers of government. And so what I get from them actually is, I never thought about going to college. I'm first generation. I'm going to go to a community college. I'm going to study political science. We've had students who barely speak English now in law school. We see an awakening, an ownership, an effort to want to do something in their community. And I know if they do something in their community, they'll only grow to bigger and better projects. I've also seen in students when their teachers have taught them to take on a project and they have to start to research it, they become interested in water. They become interested in the environment. They become interested in the fact that bus stops, for example, in low-income neighborhoods are a pole on dirt. But if you go to a bus stop in a high-income neighborhood, you get an overhang and you get a bench. So they're beginning to see through their projects this disparity in poverty, this disparity in power, and that really it's about getting involved, getting yourself heard in a collegial, respectful way to effectuate change.
And I'm curious about how you think we've gotten to this point where so many people lack understanding about government and feel alienated from government and don't trust government and don't even think about government as necessarily the solution as much as they do the problem. And how do we get to the next phase?
You know, I can't say exactly why I think society has taken less of an interest in government in order to sort of deconstruct it and think about the three branches and think about when a decision is made and you don't like it, why, who made it, and how to unwind it. And yet, I think regardless of the fact that we haven't thought about that up to maybe the last 5 years, what galvanizes people, I think, more and more is that because of social media, information is spread more easily. We're more aware of each other's environment, surroundings, hardships, that we can identify more with people. And as a result, we are a little bit more outraged. How can that happen? And then we worry about, frankly, it happening to us. And so I think there's more of an awareness, more of a I should do my part. Plus, I think with the advent of diversity in government and in business and in teaching, we're reaching more and more communities, and people are coming from communities that have previously not been heard or previously been distressed, and they're beginning to see it's safe to venture into these projects and these collaborations and to speak up for themselves.
So you mentioned about how students notice these differences as when you go from one neighborhood to another based on income or race. And a big emphasis of yours has been around equal justice for all Californians. And I wanted to talk about that effort on your part and what that means. What does it mean to you that there should be equal justice for all in California?
You know, Mark, I think it came into high relief for me when, in the Great Recession, when we were shutting down courts and we were laying people off and we were shutting down times courts were open, is I heard from a constituency of people who were also in their real life being treated poorly. They were being wrongfully terminated. There was wage theft. There was problems with conservatorships, and families were falling apart. And people who were in dissolution had problems getting court hearings and custody issues. So when there's foment in the environment and they can't get their day in court, it manifests itself as people in need. So that's who we were hearing from. And I think that's when it really began to crystallize that this is about equal access to justice. And you need it most, frankly, when times are dire. When times are fine, you don't really see a lot of the family law and landlord-tenant eviction issues. But when the economy is in strife, that's when you see the people whose society has forgotten, and that's when the laws are most important, but we weren't open for them. So that's when I started thinking about truly what equal access means, particularly in times of immediate service, crisis. And then, of course, about that same time, Martin Hoshino, our administrative director, came from corrections. And he had seen a great deal of government in action and inequity and brought ideas and policy as to how we could make our ideas gel. And we've been on that track ever since with fines and fees and bail and language access, because we think we represent the voice of the unspoken, the voice that isn't heard in the din, the voice that has no power, the voice that might not have an education.
So tell me about bail, the bail system, and how it operates today, and what are the impediments to equal justice, and what can we do about it?
Well, in all fairness, bail has been around for decades. When I was a trial court judge in the 90s, bail was just an automatic reflexive action. You're arrested, I open the book, you stole a car, I put my finger, that's a $5,000 bail. Little thought, here's a figure, you accepted it, the bail bondsman waved to me from the back of the room, he's gonna make bail, and then of course the family put up 10%, which of $5,000 are gonna put up $500. That 10%, contrary to popular belief, does not go to the court. The court doesn't get that. That goes into the surety, the bail bondsman's pocket as profit. Whether or not charges are brought, whether or not he's found not guilty, whether or not he's found guilty and has made all of his or her court appearances. So over time, though, nationally, there was a discussion about whether or not bail should be just rethought about. Let's ask questions about bail. We don't know if it works or if it doesn't work, but let's ask questions, because we're really judging people by the size of their pocketbook. And money can be a surrogate for a lot of other things. So if we're justice, then we need to think about whether or not that is a right fit. And so we started asking questions. And we, with other states, were involved in finding out what was happening, and California decided to do our own study. So we did a study of bail. Does it work? Is it meeting its purpose? And to be fair, I named a committee. And I named a committee of people who I didn't think necessarily would get along with one another. I mean, I picked experienced judges, long on the bench in criminal law. I picked judges who were brand new. I picked a judge who used to be a cop. I picked a judge who used to be a criminal defense attorney. We picked a court executive officer from a community that might have different points of view politically. And then we put them in a room and we said, ask these questions amongst yourselves. The only rules of engagement are that you be civil and respectful to one another. And in about a year, they heard from every group that came. They heard from bondsmen's, victims groups, government groups, counties, DAs, public defenders, sheriffs, and they put together a report. And by the end of this year, they were unanimous in 10 recommendations. And the first one was eliminate cash bail, because it does not serve the purpose of protecting the community or ensuring a person's return to court. Because they found out that when cash bail is posted and you agree to pay the premium, it's often not put up by the accused. So there's no skin in the game, as we might have thought. We also did a short study, and we found out that a lot of the premiums were being paid for people in custody, coming from communities that were the poorest communities of LA, that were the most non-diverse African-American Latino communities in LA. And surprisingly, much of the bail was being paid by women working multiple jobs. Moms, aunts, grandmas were making bail. We also found out that a lot of people who couldn't afford it were putting the premium on a credit card. And so they were paying over time on this $500 10% premium. And we just thought, this is inequitable, doesn't seem to serve the purpose, and that's what started our movement towards bail quote reform.
Just by the way, if you have any questions, raise your hand and somebody will come around and take your card. I have so many questions.
You worry me, Mark.
So what about fines and fees? Where are you with that?
Fines and fees continue to be a dialogue with the legislature. Let me point out, though, that bail also is always a dialogue. It's a three-branch dialogue. Fines and fees is a three-branch dialogue. No branch can solve this without the aid of the other two. So with fines and fees, we have studied the problem. We've talked to the legislature. They're very responsive. We actually are supportive of an ability to pay fine and fee continuum. Note that fines and fees are all statutory. So because they're in statute, judges are required to assess them. And judges are required and have to explain why they do not. Fines and fees in California is, at best, a $2 billion industry. And courts are the face of collection. So sometimes courts get a bad rep because we are collecting these mandatory fines and fees, but we don't get them. We don't get that $2 billion. At least 70% of it goes to a number of worthy state and local programs. It's just that over time, the legislature, over 30 years, instead of adding new revenue, they've just tacked on $10 here for security, $1 here for a penalty assessment. And these go to some of the most arcane causes, but worthy, like submerged vessel recovery. That's one of the buckets of fine. Abalone preservation.
Okay.
And these are worthy, but why are the courts collecting them? So these are the kinds of discussions we've had. And the legislature and the governor's office, they're very sensitive, and I think we're working toward a solution. We have 3 pilots testing out a ability to pay pilot to see if fines and fees, of course, should be punitive, but they shouldn't be disastrous. So we're trying to right-size what that should be for Californians.
So if I think about your accomplishments over your term to date, I think about the power of democracy. I think about equal justice for all Californians. And I also think about the emphasis that you've placed on making sure that the judicial system is representative of the people of California, that is the diversity of California. And I'd like to understand how you think about that issue and, from your perspective, why it's important in the courts.
Thank you, Mark. Well, California's strength, I think, is the fact that we are 40 million strong and we are a majority-minority state. And I think you can take that and see that California leads in ideas and in action, and that we are an active state. And I think it's because we are this blend of ideas that come from other countries, that come from different ages, that come from different experiences like veterans, and come from people who are disabled. And so in order for California to be harmonious, when a law is passed by the legislature, and when the courts are left to interpret that law, it only benefits when we have that diversity around the table talking about the law from their lens. And I mean diversity, and I've said this before, writ large. I mean, it's about age diversity. It's about veteran service diversity. It's rural, urban. It's private practice. It's public sector. Because we all will bring a different kind of just viewpoint and takeaway from how we think that law impacts us. And so I think, especially for the judiciary, for the public to have trust and confidence in us, they have to know that our decisions are well-reasoned and thorough, and that we heard from everyone who is interested in terms of helping us interpret or clarify this rule of law. So it's critical, I think, for the judiciary, because we're a country of rule of law. And as was jokingly said recently at an event, they said, well, no one's rioted so far over the Supreme Court decisions, and we like to keep it that way. And I think the same is true for our policy initiatives at Judicial Council, because we make policy for the practitioners and the over 4 million plus pro se litigants who come to court. And so we look at things and we say, hey, what about language access? California has 200 different languages and dialects spoken in the courts every day. We need to make sure that our forms reflect the ability for people to have and understand their day in court. So it is our diversity that makes us, I think, a little more understanding and open-minded. And I think that's critical for the judiciary in particular.
Is there anything in particular you're working on to connect the diversity to a system that people would feel is more inclusive, more equitable? You know, how do you then connect the diversity with an outcome in which people feel that justice is more equal?
I think, at least in terms of justice, I think part of the connection of diversity and people to the work that's being done is the fact that if you were just simply to look at us, you would see that the California Supreme Court, which has 7 members, is an incredibly diverse group, right? We have Leandra Kruger, a woman, African-American, Carol Corrigan, woman, Caucasian. We have myself. And then we have, in terms of our male colleagues, we have Ming Chin, Chinese-American, Goodwin Liu, Taiwanese-American, Mariano Florentino Cuellar, who's a naturalized American, Mexican-American. And then, of course, we have Josh Groban. And we used to joke, sort of amongst ourselves, that when Justice Baxter left, we didn't have a white guy on the court. And then, of course, things changed. But also there was a time in, at least my tenure on the California Supreme Court, where our age diversity was so rich.
Yeah.
And that really fills our view as when we look at facts and we look at laws applied to those facts, because we have someone who might be a bit older versus someone who's younger, someone with small kids, someone with grandchildren, someone from a farming background. It really does fill and, I think, inform our decisions and our questioning on the bench, I think, that people can view and see.
So I have a question to ask you about the Supreme Court and your role as Chief Justice. One thing that I've noticed is that when we talk about the U.S. Supreme Court, we're always talking about 5-4 votes, right? And when we talk about the California Supreme Court, we're never talking about 5-4 votes. And I read the recent decision around Trump's tax returns and whether he should be on the ballot in March, and that was a unanimous decision. And I read the arguments from everyone, and there was consensus. So you have a diverse court. We live in very polarized times. How do you manage to reach consensus, collaborate, and find common ground?
Thank you. I appreciate that, because it is not by happenstance that we are often a unanimous court. But I will first say, of course, it always comes down to the individual, of which there are 7 of us. And I think the California Supreme Court is blessed with really open-minded, thoughtful, kind people who have life experiences, each of them, that they bring to the table that makes them want to treat each other with a lot of dignity and respect and humor, because we know what our role is. And we know that while we may agree on this case, we will disagree on the next. And so when we do disagree, we disagree in the kindest way. I know I'm going to get a no, for example, when one of my colleagues starts with saying, I really appreciate your memo. You did such great work. I'm like, this is a no. But I also appreciate that at the same time that he or she may be doing that, he's also educating the newer people on the bench to also open in that way, which just sort of blunts the hurt a little bit more. And also because I would say this, we have a very different preparation system than the United States Supreme Court, because we actually front load and prepare our oral arguments and our cases before we actually hear the attorneys argue the case. So we are all familiar with the facts, we're all familiar with the law, we're all familiar with the positions of the parties, and we get into oral argument to test different theories. So at that point, for example, if I'm the author and I want to try to get a unanimous decision in all situations, I am going to hear all of my colleagues' complaints, and I'm going to try to accommodate them to the point where, as much as I can, as long as it does not interfere with the core principle of the rule that I would like to write. So if they say it should be shorter, or don't use that example, or please don't cite to that case, or could you use different phrasing, all of us on the bench are willing to make those kinds of professional, collegial accommodations if it doesn't harm the ultimate rule of law and the analysis that we hope to put forward. So we work hard at that, and I think it pays off.
Mm-hmm. Well, it definitely does, and it's very different from what the public sees and hears, not just about the Supreme Court, but about all of the branches of government these days. So it would be something that I think people would like to know more about, how those decisions get made and how you were all appointed you were appointed by different governors, right, at different times.
Right, exactly. Well, one of my colleagues who's now retired was asked, what do you do when your colleagues absolutely disagree with you? What do you do when you want to be right, you know you're right, but they disagree? And she said, well, I bold print my objection. I underline it and I italicize it.
And that works, huh?
That does.
Yeah. When right before this, we had a small reception, and Karen Skelton mentioned that Karen mentioned that you went to high school together. So I wanted to know, what is it about your personal story that informs your work as a Chief Justice?
Well, Karen and I, like Scotty, went to a great school that was known for its diversity before that was probably a word. Mm-hmm. And I just remember a fluidity of people, not cliques. And we all were involved. We have a common ground, student government. And I think that it was just an environment where we felt we were in control when maybe we weren't, but we felt like we were. And so we took that, because I know Javier Becerra went there also. He was within our years. I think it was Karen, Javier, myself. And we all had the bug of public policy. Mm. But I think for me, the greatest influence that has to be for so many of us is my family and upbringing. My mother and father as farm workers, and then becoming state workers and saying education is the best thing, and being the youngest in a large Filipino family where no one listened to me. And so when I heard you could be a lawyer and you'd get to speak uninterrupted for lengths of time, I said, that's my job.
That's great. That's great. Lots of good questions coming from the audience. I also know that you were a blackjack dealer early in your career, and wanted to know, before you were a lawyer, and what did you learn from being a blackjack dealer?
Thank you. Well, it was in my first year of law school, and I had a job in a defense firm, but it was only for credit and not for cash. And so UC Davis had Harrah's on site, and they were looking for young dealers, and so law students and med students and undergrads were showing up for the interview. So I showed up with my roommate, and we were hired for that summer between what they now call first year rising, I suppose. And what I learned dealing blackjack was how people bluff, how people think they know it all but don't, the bravado. I learned what a drunk person looks like and how they behave. And I then went after, sometimes during the holidays, the rest of my law school years, I'd fit into Tahoe and I'd deal for Christmas holidays. And then when I picked my first jury, the first case I had was a DUI, driving under the influence, and that I knew. I could question witnesses with that because I had some experience from reading witnesses and picking a jury from those days.
Life experiences is good.
Yes, exactly.
It really is. We have some great questions from the audience, and I just want to intersperse a few of them. This one I think is very interesting because in one of our recent polls we found that homelessness was tied as the #1 issue in California. It says, what is the court's position regarding homelessness? It's an interesting issue legally.
That's interesting. And you know, the court is of a place where we see what's happening out there. We are often referred to as courts of last resort. We don't get involved generally unless we can be proactive in some legal way, or if the case comes to us because it is a live controversy or a dispute. But what we have in our courts are what are called collaborative courts. So we have homeless courts in addition to our landlord-tenant courts. But in our homeless courts, we try to reach out to what is this homeless person charged with? What is the criminal conviction charge that brings them to court? But what is the underlying problem in their life? Is it mental health? Is it drugs? Is it alcohol? What is it and we try to pair them with a program that can fix the underlying issue, because we all know that homelessness is a symptom. It's not the problem, it is the symptom, it's just visible to us. And also, homelessness doesn't happen overnight generally. It is a downhill path. And so we try to intervene and we try to prop up. To the extent that we can, we try to ensure that a homeless person who comes to us can clear their record, can clear any outstanding charges, can clear warrants, that they walk away from court not having to pay any fines and fees, which we know they're incapable of paying. We don't want to burden their life. What we want to do is remove some of the burden so that they're in a place where that they can be directed for help and that they can start to be back on the track of putting their life together. That's where we are. We think about it. I mean, Martin and I have talked about courts. They close at night. Are there ways that we can use the courts to house people in times for shelter, for weather conditions? Is there some way that we can be of service? Because we know how hard it is, and it's heartbreaking.
That's really interesting. A related question, and you can raise your hand if I mention your question. That was your question, first one? Good. Oh, sorry. I have a related question that I want to mention. But raise your hand and get the question written. Somebody will take it. So somebody else says, thank you for your support of collaborative courts. Maybe we could talk a little bit more about what that is, particularly those working with diversion of people with behavioral issues, behavioral health issues. What do you see going forward to promote these courts throughout the state? So maybe we could talk a little bit about what a collaborative court is.
Collaborative courts are courts that are in a courthouse that delivers, I think, a non-traditional kind of justice. It focuses on a discrete, vulnerable population who has run-ins with the law. And they come into court, and let's just call this a domestic violence court. I used to run a domestic violence court. So we take folks, both misdemeanor and felony charges of domestic violence, we bring them into court, and we have in that court services that are particular and specialized to people who might have that problem in their family life. And so we provide social workers, we provide counselors, we provide people who can be contacted if there is a threat of domestic violence in the home while the person is on probation. So a collaborative court is a specialized court, and it's to fix certain issues in a community, and different communities have different issues. So some courts have veterans courts for people who come back from service, who have issues with homelessness or issues with low criminal charges or drugs or alcohol. And these veterans courts put these folks in charge with veteran services. They try to find a way to help them out of this situation. California is known for collaborative courts. We lead in collaborative courts. They're sometimes called restorative justice courts. But here's the only thing about collaborative courts. They're expensive. And so because they're expensive, we don't have as many as we'd like. We do special training for judges. We do special training for staff for these specialized courts because it's a specialized, fragile population. The whole point of a collaborative court is to end recidivism. Now, the good thing, though, in California is the legislature really sees the need for these courts. They like them, and they'll fund them. But at the same time, we have to think about equal access to justice. And so we need to always make sure that we have courts open for people who don't necessarily fall into the specialized treatment programs. But we have a variety of collaborative courts, mental health courts, veterans courts, homeless courts. The variety comes really from the community. If the community sees a problem, wants that court, they work with their court to create it and staff it.
That's good. We're going to come back to some of the audience questions in a moment, but I want to get back to a comment that you made about one of your other high school classmates, which is the Attorney General. And our Attorney General has been suing the federal government quite a bit, since I think 50 times or so. And I want to get your sense of where we are in terms of the federal and state relationship. I mean, you had some issues around who was coming into courts and what you felt about that. And you, I think about a year ago, announced that you left the Republican Party. So where are you in terms of the federal-state relationship today?
Well, I would say first of all that the reason a case from the California courts crosses over into the federal courts is only because the federal Constitution is at issue or there's a federal question that's common to both that case. So most of California's cases do not cross over to federal court. So we don't really have a legal relationship with the court. Of course, whatever the United States Supreme Court rules is the law of the land as the highest court. But for example, when the 10th Circuit or the 7th Circuit or the 9th Circuit has a ruling on the California Supreme Court and the California judiciary, that's only persuasive authority. It's not binding on us. We read it, we look at the logic, we look at the analysis. So our relationship with the federal courts is not as close as one might suspect, but our collegiality with our federal brethren in the Eastern District, the Northern Central District, and in the 9th Circuit is tremendous. We sit on a lot of committees together. We share a lot of our concerns. But I will say for California, sort of symbolic of Javier Becerra's, I think, 55 plus lawsuits against the United States government, is that we, at least I, as the Chief Justice of California, really guard the judicial branch lane. I guard that lane. And I guard that lane because no one else does. And I don't expect anyone else to guard that lane. So for example, a few years ago when the federal government, when the Homeland Security was Kelly and the Attorney General was Sessions, and I learned that they were making civil immigrant arrests in courthouses in California, which they had been doing nationally, and I hadn't heard anyone speaking out against the national action. I was waiting for my chief justices from other states to speak up. I really didn't see that. Didn't see a need for me to speak up until it happened in Pasadena. And then at that point, I wrote a letter to Sessions and to Kelly, objecting in very strong language to the policy of arresting on civil immigrant warrants in California courts. Because I realized as a judicial officer, I couldn't take issue with the actual immigration law itself. That's not my lane. I'm in the judicial lane. But I can take issue when the executive branch decides to execute a policy that I think entrenches unfairly and unwisely on the judicial branch on a state court, because it was terrifying people. When ICE vans were outside particular metropolitan courts in Southern California, it emptied the court. And yet we know that the laws are for everyone. Our laws do not apply. They apply whether you are here undocumented or otherwise. There is no restriction on that. People come to court for refuge. They come for aid. They come for protection. We in the state courts, we encourage that. We have children's waiting rooms. We have lactation rooms. We ensure that people come and they can bring their family and have their day in court. And I felt that that policy was in violence to everything we do at the state court level. And so I spoke out.
So could I ask you about your change to no party preference?
Yes. See, some of my Republican friends are here, and I will just say, but as I indicated, I am a Duke-Majan Republican. Have been, and in spirit, still am. But I felt that in my role as Chief Justice, that is not political, that looks at the rule of law, to stay out of the fray, I needed to leave that label behind. And I will be honest, I had been thinking about it, I had been discussing it with some of my Duke-Majan colleagues at the time. And I think for me, the greatest impetus, honestly, was my two daughters and their reaction to the world stage of the confirmation of Brett Kavanaugh, no matter how you may feel about that. It was the atmosphere, it was their reaction, and I just felt that I needed to take myself out of that equation. And the truth is judges decide things apolitically, so it didn't affect me professionally, and I did it very quietly. And then one day, I think Dan Moraine from Cal Matters called up and asked for a clarification on my bio, and then it just sort of took off, and that was it.
Well, for the record, I'm no party preference too, and I made the decision a few years ago because it just clarified my neutrality in a way that, for my work, I needed to do. So I appreciate that.
That's well said. Thank you.
Some of the other questions, we have some great questions from the audience, and I want to make sure that we hear some of them. What is the most pressing criminal law issue in California?
That's a good question.
Yeah. Who asked that question? You can raise your hand if you don't want to.
Well,
you can be anonymous too, but it's a good question.
So as you know, criminal justice reform in California has been ongoing, I think, since Jerry Brown, 2011, when he took office as governor for the third time. And I would say that every year, if you look at what California has done, it's done criminal justice reform every single year in many, many ways, and Gavin Newsom is on the same track. Also, at the same time, we've seen initiatives in California that have really changed criminal justice reform. And it's affected everything from credits to enhancements to priors to terms to locations of where you're actually tried. But to be honest, I will say the greatest challenge California faces now is implementation of Prop 66. So,
could you explain that?
Right. So on the last round of ballot initiatives 2 years ago, there were two initiatives in front of voters. And one was to speed up the death penalty, and one was to abolish it. And they were very close. But the initiative to speed up the death penalty prevailed. And that's Prop 66. And it has a host of requirements for courts now to implement to try to speed up the death penalty. And now there's many complications to it. But the Supreme Court had ruled that actually this initiative couldn't be required, it's directive only. So we have to make every best effort to speed up the death penalty so that more people theoretically could be on death row and ready for execution. At the same time, we have a governor who declared a moratorium on death penalty cases and then dismantled the death chamber.
Yeah.
So at the same time, in federal court, in California now, if we were to have an execution, it would be with a 3-drug cocktail. It's no longer by gas. And so that 3-drug cocktail is being litigated in federal court. It's out of our hands as to the legitimacy and the cruel and unusual nature of that 3-drug cocktail. Then there have been a whole host of challenges to the cocktail, like we can't get the drug in California. Doctors are not interested in actually injecting the cocktail. So we have a host of problems, and so the courts follow the law. So we are trying to implement Prop 66 with no additional funding and with all of these legal challenges.
Death penalty continues to be one of the most difficult challenges for the courts. Here's an interesting question, and it touches upon some issues we talked about earlier, but more specifically. Could we have special courts in different languages? Maybe you could talk about what we do in terms of languages with courts.
See, that is really important
Yeah.
because I think we all know that your day in court means nothing if you don't understand it.
Yeah.
That's plain and simple. And so what we have in California has done, we have really tried to capture the strength of California by increasing our language access. So several years ago, I commissioned a study of language access in California through the Judicial Council. And then the Judicial Council members and people who were involved in that came back with a list of recommendations. And then Justice Cuellar from the Supreme Court, he implemented the recommendations. So now, as a result of implementing our language access plan in California, we have the best language access in the United States. It's still not enough, probably, by many people's standards, but we now have much, much more money in language access such that we now provide, and have always provided, interpreters in criminal cases, but now interpreters in civil cases, particularly in those heart-wrenching civil cases like family law, landlord-tenant, unlawful detainer, conservatorships, guardianships, and probate. We also now provide interpreters at the windows, the service windows, for people who have to file and fill out forms. We also now have our website for self-help and our website for forms, legal forms in California, in at least 2 languages. We have Spanish and we have English. We're looking to add languages, but that will cost additional money. We're also studying ways that we can, through a pilot program, provide many, many different kinds of interpreters on demand to counties that need them. So if you're way north in Shasta and you might need a Punjabi interpreter on a Friday afternoon, otherwise that person can't get out of custody, we're trying to implement a pilot project so that you can, not ideal, I know, but that you can use an interpreter through a Skype project so that that necessary interpretation can happen so that case can move. So we're looking to be flexible. We're looking to do as much as we can to provide interpreters in California. And we are trying to do it with more and more money. And frankly, Governor Newsom and Governor Brown have been very generous and very favorable on this judicial project.
Language, incredibly important issue for equal justice for all. There's a question that was asked. Women and children occasionally become homeless through no fault of their own due to domestic violence. How can they be rescued?
That's another great question. The way that we think we can be of service is if a domestic violence case comes to court, then I know that when I ran a domestic violence court, I want to hear from the family. And I'd like to know what you need. And we like to be what we can and provide what we can. You know, what's interesting is more and more, what you may not realize is that California courts are becoming social justice centers. We provide the service, we provide the connection to the counseling, the connection to the place where jobs are for interviews. We provide the connection for family counseling. We provide anger counseling. So if you come to court, it usually has to be attached to a case, otherwise we really have no jurisdiction or no reason to be in the business. We can maybe make references, but we are able to try to connect you with some community service that we can provide or that we can find in your community for you, even with language. So that's where we are. If you come to court, we try to provide it.
We're almost out of time, but I want to ask you a couple of other questions. One is, if you look back at your time in the Chief Justice role, what do you consider some of your biggest accomplishments to date, and what do you see as the challenges as you continue in this term through at least 2022?
Well, I think, at least in terms of as I look back, what I feel proud of, I think, is the fact that the California judiciary is a collaborative, problem-solving entity. I think that we are inclusive. We ask questions that people don't like, but I feel that we have to ask the question. And we have to ask the question with civility and respect for others, and we put it out there so that people can disagree with us so that we can get to the right answer. So what I'd like to think is one of the greatest contributions in the last 10 years is that we are a fair and just collaborative entity. And we ask hard questions and we do good homework. So for example, I think you'd be challenged to find any public entity, purely public entity, that does the kinds of reports that the Judicial Council does in terms of domestic violence, in terms of homelessness, in terms of fines and fees, in terms of bail, in terms of the impact on the poor. It would be hard-pressed to find any public entity fully funded that does those kinds of deep dives, that provides these reports to the legislature. And I think we do it with deliberation. And we do it even when the question angers our own. But of the view that we need to ask this question because we need to self-assess. So I think one of our traits in the last 10 years is we self-assess. We ask ourselves, how are we doing? And we're honest when we're not doing well. And so I think that's colors everything about what we do. That's why we look at fines and fees. That's why we look at bail. These issues have always been around. These are just fresh eyes on old issues.
Yeah. And the big challenges, you think, over the next few years?
The big challenges will be sustainability, stability. It will be survival in the next recession. It will be ensuring that we can continue the good work we're doing on pretrial reform, on fines and fees, and on collaborative courts.
If you look Is there any particular issues which you think are going to surface the next year or two that'll be new or different for the courts?
Well, it's hard to say that there's anything new or different, except I would say two things. 2020 is an election year, and you may not realize that the court gets inundated with election challenges. They come fast, they come furious, and they come emotional and inflammatory. So I am...
In what form?
In forms of challenges to ballot titles, and challenges to people's representations of their credentials on the ballot, to challenges to the constitutionality of the initiative being offered. So we'll be facing all of that on top of the fact that we are still litigating all of the criminal justice reform matters. Because even though the legislature and the governor and the initiatives passed all of this criminal justice reform, they didn't tell us if it was retroactive. So we're now figuring that out for a wide swath of reform. So we're figuring that out, and then there are new initiatives coming. And then, of course, in 2020, we're all sort of waiting with holding our breath for the Privacy Act and what that will entail and what that will mean for California courts.
I'm afraid our time is up. I can't believe the time went so fast. But we covered a lot of territory today. We're so fortunate to have you in the leadership role of Chief Justice. And we're very fortunate to have you here today at this time. And can we give a big hand of applause for the Chief Justice and her work? Thank you. I want to thank everybody for joining us today, and we look forward to seeing you in the new year. You'll be hearing from us shortly after this event today. We always send out a survey and ask you how we can make these programs better. I want to thank the supporters, as well as those of you who've joined us online and in person today. And we'll be seeing you next year as our 2020 speaker series starts with an event with Secretary of Defense, former Secretary of Defense Leon Panetta, who will be here on January 16th. And then we have some other exciting programs that are planned. So we look forward to seeing you. In the meantime, have a wonderful holiday, happy holiday, and the best for the new year to all of you. Thank you very much. What a pleasure. What a pleasure. Thank you.